Ready? Start. It has been argued by learned counsel for the applicant that impugned order is arbitrary and against the provisions of law. Full stop. Applicant was falsely implicated in this case. Full stop. Applicant was seriously ill and that it was only on few dates that he could not appear before the court, comma, which resulted into issuance of non-bailable warrants. Full stop. It was submitted that applicant himself has surrendered before the court below and he was granted bail wide order dated 7/12/2019 subject to condition that he shall deposit amount of his earlier personal bond, comma, which was executed in pursuant to the bail order dated 9/4/2019. Full stop. It was further submitted that applicant moved an application for recalling the said condition, comma, which was rejected wide impugned order without assigning any reasons and thus, comma, impugned order is illegal and liable to be set aside by this court. Full stop. Per contra, learned AGA has opposed the application and argued that if applicant was having any grievance with the bail order dated 7/12/2019, he ought to have challenged the bail order dated 7/12/2019, by which said direction has been issued. But applicant is challenging the order dated 8/1/2020 by which his application to recall the above stated direction oblique condition has been rejected. Full stop. Learned AGA has further argued that there is no illegality or perversity in the order impugned. Full stop. It is apparent from the record that in above noted case, applicant was on bail but he did not appear before the court below on dates fixed, thus non-bailable warrants were issued against him and his personal bond was forfeited and process under section 82 CRPC was also issued against him. Full stop. His application for cancellation of non-bailable warrants was rejected wide order dated 6/12/2019 and he was sent to judicial custody. Full stop. Thereafter, applicant was granted bail wide order dated 7/12/2019 subject to condition that he shall deposit the amount of his earlier personal bond, which was executed in pursuant to the bail order dated 9/4/2019, within 1 month. Full stop. Thereafter, application of the applicant to recall the above stated direction was rejected wide over impugned. Full stop. It is clear that the condition to deposit amount of personal bond was imposed by the court below in bail order dated 7/12/2019, but the fact remains that said bail order dated 7/12/2019 is not being impugned in the present application under section 482 CRPC. In fact, an application was moved before the court below to recall said direction, which was rejected wide impugned order dated 8/1/2020, full stop. It is well settled that criminal court has no power to review its order except to correct clerical or arithmetical error, full stop. Thus, no fault can be found in the impugned order, full stop. If applicant has any grievance with above stated direction to deposit the amount of personal bond, which was issued wide order dated 7/12/2019, applicant ought to have challenged the order dated 7/12/2019, but that order has not been impugned in the present case, and therefore, it cannot be said that impugned order suffers from any such illegality, perversity or vice of abuse of process of law, so as to warrant any interference by this court, full stop. However, in case applicant chooses to challenge the above stated direction by impugning the bail order dated 7/12/2019, the same would be decided in accordance with law, full stop.